Yes.
Adjournment request, if any, from item number 1 to 6. From item number 22 to 27, adjournment request.
25. Yes, Mr. Boyan.
My lord, may I please, your lordship, my lord, I beg to mention item number 24, my lord.
24.
24, my lord, PIL, my lord.
Hmm.
Lord, we have been led by outstation senior counsel, my lord. Today there is some difficulty for on his part, my lord.
As
Lord,
paid for on behalf
my-
of the petitioner, let this matter come up for consideration. January.
my lord, my lord.
Yes,
Oblige, sir.
My lord,
6 January.
item 25, my lord, we have.
adjournment
circulated-
slip has been circulated with the consent of the other side. Let this matter be circulated.
My lord,
Let this matter be listed sometime in January. Yes,
in item 28 also, my lord, it's a
28 also.
PI
Continue.
concerning eviction, my lord. Some developments have taken place. We would like to bring it on record, my lord.
You are for respondent.
Respondent.
Forest Department. As prayed for on behalf of Forest. Have you informed the other side?
Other side has been informed, my lord.
Are you sure?
Yes,
Or let it be called out and that you mention.
Then-
All.
I mean,
No, this working plan for forests, some
Working plan.
affidavit had to be given.
yes.
Anyway, as prayed for on behalf of the respondents, after informing the council for the other side, let this matter be posted for further consideration in January. Okay. Okay.
19 January.
Oblige.
Any other request?
Wait, please, Your Lordship.
Yes,
Lordship, I beg to mention for listing of a REIT appeal, Lordship, which is already listed in the part 2 list, Lordship. And it be on first week of December, Lordship.
why not? But what is the matter?
This is with regard to the Lordship termination from service, Lordship. The petition has been terminated on 19/6/2023, Lordship.
First week of, second week of December.
Second, on 11 December.
Oblige. May it please, Lordship. Lordship, I beg to mention one REIT appeal for listing. Lordship is being a long pending matter and the matter is already listing in hearing.
Which is that matter?
Lordship promotional benefit.
Yes. Sometimes in December. Yes, December,
December. Lordship,
not November. There's a lot of matters here. Then this bench also has to go to outlying court. December. Take a date in December.
Lordship.
May I please, Lordship? I am paying for listing a contempt case matter. It was last listed on 3rd of November.
Hmm.
Lordship, finally, next week on 12th November.
What is this content for?
It is
Which
a-
order has been violated or not respected?
It is a non-compliance of court's order.
That's all right. Therefore, the content petition has been filed, but what kind of an order? What order? Dealing with what? Come back again on the next day when you read the file and then make a mention. All right, yes.
My pleasure, Lordship. Yes, I beg to mention for IA criminal or listing IA criminal for orders, Lordship. This IA has been filed for
This criminal mentioning goes before DB two. Huh?
Date reference.
Death reference.
yes.
So what is this?
Life
IF?
imprisonment was given, Lordship.
Life-
Life
Life imprisonment. It goes before, you have to mention before DB two.
Oblige.
Daily list for orders, item 1.
In this matter, we are supposed to file a response to the affidavit of the government, my lord. I need further 2 weeks' time.
There's nothing left in the matter. We would direct them to appoint the committee in terms of the act.
No,
With the promulgation of the act, I think the decree of 1939 or 40 or whichever is the date, that gets superseded.
true.
The act comes into force and it supersedes all other decisions.
My lord, there has to be a scheme, my lord. I'll submit a little on that. Your worship is
Anyway,
right, my lord. I'll submit.
Pursuant to the affidavit filed on behalf of the respondents, Mr. M.K. Chaudhary, learned senior advocate, wishes to respond to the same, and for that purpose, he seeks a short adjournment. Let this matter come up for consideration in January 2036. 26, yes.
Oblige, my lord.
9 January. Item 2.
May it please your worship.
Barkandaz. Barkandaz.
My lords, driver, my lord.
You appear for respondent. Who is the respondent? Respondent number? 3. Private respondent. The person who has been appointed
Yes, my lord.
while he did not have a driving license.
I have, my lord.
Put in your response, file your affidavit.
My lord.
We have taken this up despite the fact that the appeal was filed after 3 years of your appointment.
Yes.
We have taken it up for the reason that he got to know very late that on the day when you applied against that post and you gave your affidavit, that was the day when you were a minor.
That was the allegation.
Allegation.
Yeah.
So you have to put in your
My
response,
lord.
right?
Yes.
Okay. What is the name?
Eighth.
Mr. A. Dhar, learned advocate, has appeared on behalf of respondent number 3, private respondent number 3, who would file his response to the memo of appeal by the next date, January.
Matsu.
Obliged.
21st January. Item number 3 to 21.
Yes,
My lord. Last time they filed in my lord,
yes.
a copy of the my lord. Minister, first copy of the my lord, the person in respect of all the petitioner my lord.
Yes.
May I read that my lord, that copies my lord, which has been served to us. One is Monmil Boro. So far petitioner number 1 is concerned.
Very good. It is not there. Well, yeah. Fact sheet. List, yes.
One is Monmil Boro. They said original inhabitant of Soigao, Kamrup district, and cause government land reserved for TB hospital in Guwahati since 1992 by constructing bamboo house, my lord, Kali room, and served with the eviction notice in the year 2010.
Hmm.
Litigating since then. Nowhere they have stated that I have a land in a particular, whether in my native place or Guwahati, my lord. So for saying, my lord, same thing has been second
Mr.
to
Botpuzari, you just said not eligible. Where is the other statement?
my lord, regarding my lord that.
No, no. We start with first. Where is the other statement? That he doesn't have any house, any land anywhere in the state of Assam.
Yes, my lord, for that reason, my lord, we are relying, my lord, on the statement because they have stated, my lord, while, my lord, they have appeared before the co-district commissioner. When
No,
that,
if you rely on their statement, they would say that they don't have any land.
my
You
lord,
agree to it, then you'll have to make a scheme for them, no?
now, my lord, the difficulty here is that, my lord, in the speaking order, my lord, the provisions of land policy that has been relied upon specifically deals with, my lord, Guwahati city. And that, my lord, I have incorporated,
That's different, but no, at the moment we are at this,
my lord.
that what inquiry have you made with respect to persons? Now, not eligible for what reason?
My lord, not eligible because of the reason, my lord, that first of all, they will have to be an indigenous person of the state of Assam.
Where have you said it is not?
My lord, for that reason, my lord, if lordship. will
You should
please-
have given a reason, no?
Yes, my lord, the reason is here, my lord.
Where?
My lord,
If you're asking us to go through the fact sheet or a flow chart, it should be reflected there.
my lord, absolutely correct. But here, my lord, at the, my lord, page number 12, my lord, the last but second page. I'm traveling, my lord, with all the pages. my
Page
lord.
number 12.
Page number 12. There I have, my lord, incorporated the relevant provisions, my lord. Because to some, because these are the provisions that will be generally applicable for all the, my lord, appellants.
Hmm.
Relevant provisions of the land policy, lordship got it, my lord.
Yes, yes.
Lordship may kindly see, my lord, 14.2. This is not under denial by them. An indigenous person who has no homestead land in his name or in the name of his family in the state may be eligible to get land in Guwahati city or in the urban area, provided that such person is required to reside in Guwahati city or in that urban area by very nature of his occupation.
You should have
service.
said that they have not made any such disclosure in their application.
Yes, my lord, nothing, my lord. But therefore, my lord, I have put it in, my lord, in this way. Otherwise, my lord, this chart will become cumbersome, my lord.
No.
My lord,
One line will not make the flow chart cumbersome. That there is no disclosure that they have no homestead land in their name or in the name of their family in the state. And that their occupation requires them to stay here.
No, therefore, my lord, we are relying on the statement because hearing has already been concluded, everything has been recorded, my lord.
Kobula format করলো। আমরা বানাবো। কবুলা test করবো। সংক্ষিপ্ত নাম দেবে কবুলা করবো। And in that form.
Yes, Mr. Chaudhary.
Yes, my lord. What my learned friend has submitted, my lord, the statement has been recorded by them. We take categorically stand in the or a petition as a affidavit, my lord, that they have written, my lord, it took the signature blank, assuming but not admitting. The statement is correct. What the statement is, my lord, you'll also kindly come to the page 382.
Page
382
of
of my lord petition, my lord. Memo of appeal, sorry. Repeat.
yes,
382. Sumon Devi, my lord. First, because they are attacking in respect of indigenous people, that I am reading Sumon Devi. I, Sumon Devi, sound health personal knowledge, do have a given statement attending before the co-district commissioner, New Guwahati, co-district, my and my husband house is Uttar. Since then, we are very poor person profession in the
That
19.
you are by the very fact that you have no land in Uttar Pradesh is no.
I'm coming, my lord. That is the statement has been recorded by them. And your lordship kindly come to the Kobula of Sumon Devi. This is the format. We have to give that format, my lord. Lordship kindly come to the page, my lord. 113, my lord.
No, we will know. The writ petition will come to that. Where is the Kabula?
Yes, my lord. Page, my lord, 113, my lord. All the person Kobula is there, my lord.
Yes.
There is a specific memo of appeal, my lord.
Page 113.
113. Para 5.
You had shown that.
And para 4
That's
and
all
5.
right, but you hail from where?
I hail from, I also for Mamil Doresa, he's from my Kokrajhar. On 10 years, he's come, sorry, 21 years, he come to Guwahati, my lord, for the job, my lord. I said that my ancestral house in Kokrajhar, I am expecting statement that I have a no land, my lord. In my affidavit.
No, the translation that you showed us at page 389, that
Yes.
was of Suman Devi.
Yes, my lord.
This is by Manuel Boro.
Yes, my lord, I can.
No, but
Suman Devi also submitted the Kobula. Form is same, my lord.
The form is all right, but then here in this form, the necessary information
Yes, my lord.
is asked in this form.
Yes, my
You
lord.
are in occupation of which land, you hail from which place.
No, my lord. Page 113, my lord. Come, my lord. Para 5. Para 4. Any settlement of the aforesaid government land within the permissible limit or government land for 90 days. The excess land occupied here by member of my family shall be vacated. Following which so within the government norms the applicable said to be liable. That it is provided myself any other my family owner patta land within the Guwahati, then the settlement has been made is liable to be cancelable forthwith. Does this settlement be? Para 3, my lord. Sorry, my lord. Neither myself nor any member of family possess, occupy any other land within the city of Guwahati except the land stated above. Para 3. And this affidavit is same for all, my lord. This affidavit is same for all the person, my lord. And this is their format, my lord. I want to say I have neither land in Uttar Pradesh, my lord, nor land in my lord, Guwahati, my lord. Only that land I have possessed, my lord. And their affidavit in this respect is silent. And another I want to stay from the statement, my lord. We have categorically stated 2 persons were settled the land. In our statement also, my lord, our representation also. But in my lord speaking order, your lordship, one line order that you are not entitled, sorry.
Yes.
Yes, my lord. Lordship, I have always shown from the Kobula, my lord. Suman Devi Kobula is, my lord, page 166. In the Kobula, I have stated, my lord, I have not possessed any land in Guwahati. In statement, I have no land in the native village, my lord. And I have categorically stated 2 persons were settled, my lord. What is the speaking order? In the speaking order, nothing has been said. And there is a specific minutes of the meeting that 97 that was not mentioned in the minutes of the meeting. There are 3-4 orders, my lord. Circle officer verified and SLSC passed. 4 persons were settled. They have categorically said land not belong to TB hospital, my lord. That is the crux of the issue. First, they have to decide under Rule 18 to my Kobula, my lord. Without deciding my bona fide claim by the dam, my lord, they always said, my lord, in from 2010 also said. Earlier, we also submitted Kobula. The court has directed to decide the Kobula. Nothing has been discussed. Anytime they have given a eviction notice, my lord. First, they have to decide my right, my lord, under Rule 18, bona fide right, my lord. If nothing has been discussed, they have stated they are not entitled for the land, so you evict from the land. Anyway, my lord, I am respect your lordships. He decided to give an alternative land. This is my first argument, my lord. Alternative 15, my lord, where the land bank has been prepared by the state. Nothing has been there. the PPR, my lord. They want to say only one thing. You are not indigenous, go, you go, you go. Where is that law, my lord? They have to show these things, my lord. First, a person 30, 35. And one thing, well, a very derogatory statement has been made. We are doing business. What business, my lord? A widow doing, they have my kept 2 cow, my lord, as per my instruction from my client. My lord, sell milk to the neighbor people, my lord. Does it mean I do the business, my lord? That is their submission. I want to say, my lord, in respect of my lord, land policy 15.1, my lord. 15.2, my lord. Deputy Commissioner shall prepare a scheme plan for eviction for every district as per instruction issued by the government. Such scheme should be include post-eviction plan, my lord. No post-eviction plan, my lord. Let them produce the, what is the post-eviction plan, my lord? Land bank also not prepared as per 15. Detailed report was not submitted. And my lord, deputy commissioners delegated the power as per section 3 should be delegated the power with by written by general or special notification. They will never produce the notification also, my lord. And one hand, we have produced all the document to show their land not belongs to TB hospital, my lord. They are not producing any document. From 2010, my lord, this honorable court has directed if decide get popular. Nothing has been discussed, my lord. 2020 court has said they not going my statement, even my statement and representation, my lord. Only one thing said, land belong to TB hospital, you are not entitled for that. On one line order, not discussed.
That perhaps will be difficult for you to contest. But then you are basing your arguments only on your rehabilitation,
Yes, my lord.
nothing beyond that. That land you cannot have.
Yes.
That
That is,
eviction notice is absolutely correct.
my lord, my humble submission.
Rehabilitation, of course,
Yes, ma'am.
your argument
Yes, ma'am.
has some substance.
Yes, ma'am. I'm already argued, my lord.
All right.
They not make any sincere effort to, my lord, settle the
That
dispute.
sincerity is lacking.
Yes, my lord. That is my humble submission before Lord Chairman.
Anything in reply, Mr. Boswazari?
Yes, my lord, we are relying, my lord, on 14.2. In fact, 14.2 and 14.3 is the foundation of the passing of the speaking
Have you
order.
done that exercise?
My lord, we have done it, my lord, and we are relying because, my lord, it is a pan Assam exercise. Some people, some person coming from outside Assam, Bihar, Uttar Pradesh, how can we know, my lord? We have to rely on the affidavits. That is the affidavits which Lordship has just now perused at 113, my lord, page number 113. So we have this, my lord, fixed formats. They will have to make a declaration. On their declaration, my lord, we assume that, okay, you are landless or not, to that extent. But
Well, Mr. Boswazari, see, when Mr. Chaudhary says that your bona fide is lacking, he has a point. Now, this is the format that you give them. There is nothing, no paragraph, there is no questionnaire, there is no question there, which would make them, respond that they are indigenous or not.
the indigenous, my lord, it is a subjective term, my lord. One has to be, my lord, the
State of Assam.
state of Assam. Now, my lord, our basic contention here is that, my lord, by applying the
So
provision.
therefore, you wanted information from them, whatever information you wanted, they have given.
They have
Now,
given.
where is the place where you have said that you make a declaration that you have nowhere, that you have a business, what kind of business? You should have asked them, no.
My lord,
One, you say that it's a huge exercise and the humongousness of the exercise would prevent you from doing it. I mean, all by yourself. You'll be relying on what disclosures they make. But you don't give them the idea. You don't give them the format of the disclosure. Now, how are you going to decide?
so, my lord, now, if I may stick to the present list,
Look at this.
My
Now
lord.
let us be very, very forthright. They can't claim to remain at a place which is earmarked for hospital.
absolutely.
No, there can be no argument for that. It is as important to have hospitals as it is as a welfare state to not let them, lead a stray life. At least basic human existence. But then hospital place, area earmarked for hospital, nearby area, they can't claim. They can't also have a choice of but your rehabilitation exercise must be good because this is your land policy.
Absolutely.
The difficult, see, this is the problem with your land policy. You can always go for a change of the land policy by bringing it to the house
Yeah.
of
Yes.
Assam,
Yeah,
because now you have less land available. But as long as the policy is in place, it is what you have decided, you will have to act according to it.
absolutely.
So therefore, an exercise at your end is very necessary. We are not at all questioning your bona fides and your efforts in making it encroachment free so that you can expand the hospital. We are not going to stop you from doing that. That we say forthright. But this is not their argument. Mr. Chaudhary and Mr. Deori, all of them, they said something else. They are not on their right of staying there. They only say that they have to be rehabilitated, and the efforts made by you does not smack of any exercise that you have taken. All that you're interested is their eviction. That is their argument.
Yes, now if I may reply in my lord in a short nutshell, my lord, we are confining ourselves so far as rehabilitation is concerned to the Guwahati city. Now let us restrict ourselves to Guwahati city.
All right.
Guwahati city is, my lord, such a scarcity of land has taken place. Everybody will admit it, my lord. So for Guwahati city, it is very difficult. And prima facie, my lord, this column where eligible for settlement, this is primarily premised for Guwahati city. Now, for outside Guwahati city, my lord, outside Guwahati city, because land policy is a pan-Assam exercise, they may choose a particular land, my lord, outside Guwahati. Now, to that extent, my lord, if I may pray, my lord,
Would you open a window for them to file their declaration and make statement giving you the choice of settling them somewhere?
yes, my lord, to that extent, my lord, to that extent, my lord, if I may humbly pray today, my lord, if Lordship may be pleased to post this matter on coming Thursday, because AG Assam is not available today, with all respect. My lord, let him make a statement, my lord.
That's-
to that-
No, that's all right. We will direct.
Only to that extent, because it may amount to, my lord, entail some, my lord, concession, my lord. I do not have that authority, my lord. Lordship may kindly, my lord, perceive that situation. Only to that extent, because otherwise all factual metrics and all consequences are before my lord. There is no hide and seek. Only to that extent.
No, but we are, again, why do we repeat same thing over and over again? Are you going to affect your land policy in their favor? Now, they can't have a right. They don't have a choice.
Absolutely.
They are choiceless people now. No, you have to show that
So
compassion.
once they are
But
out from,
compassion doesn't mean that you reclaim the reclaimed land or you settle them in some special area, wetland, grazing reserve. No,
That
no,
can't be.
no,
That
not
can't
at all.
be,
That
madam.
can't be.
that can be.
Forest, that
Yes.
can't be. So whatever is possible, you can't you can't create more land than what you have.
Yes, yes.
We understand that. But we want to see the efforts. See Olga Tellis, Sudama. These are cases which are eye openers.
I open sir. In fact, in those cases, my lord, the appropriate government had to come up with appropriate legislations. Statutes are there. Because in the Delhi case, my lord, Delhi High Court case, which Lordship has seen, my lord, they heavily relied upon by them. There is a statute. There is a statute brought in place. But here we have land policy, my lord. Here we have the land policy where, my lord, the parameters have been set. But of course, my lord, so far as this lease is concerned, my lord, I'm confining myself to Guwahati.
Mr. Bodhpujari, we are concluding the arguments today. But before the judgment, whenever Mr. AG is here, we will ask him and we will incorporate that in our judgment.
I'm so deeply obliged, my.
So we don't write anything here. Whenever the AG is available on any day, these cases shall not be listed otherwise.
My lord.
Because every day, it disturbs the balance of the list.
So
So we are not. posting it.
apologize
We
for
say that
any
the argument
inconvenience.
concluded.
My lord,
It is posted for judgment. It's reserved for judgment.
my lord.
But then whichever day the AG is here, just tell him, just remind him that he should remind the bench
Absolutely.
that he has to give
Yes.
his view.
Yes, my.
All right. Arguments heard, judgment reserved.
There is many government in Guwahati, my lord. Because, my lord, this all
Now,
land
Mr. Chaudhary, the difficulty is that all these all city capital cities, they are, burgeoning with population, and it is very difficult for us sitting here to tell the state to carve out land for you. Very difficult.
absolutely correct. But there is left.
You would not agree as a citizen. Suppose open spaces which is meant for, open air. City would not look like a city. Of course, life is more important than the look of a city. But then there are certain compulsions. We can't ask this Guwahati city to be made a settlement colony.
In respect of Kosista, now the Guwahati city is become fast now. It is not that Kamruk Metro is a area is.
Kahan jayenge? Where would it go? It's on the banks of a river. It is on the banks of the river. It has to go beyond.
My lord, in Bosista also land there, my lord. Bosista, there is many government land is there, my lord. Same person. This is the land chilling surplus land, my lord. We are occupied. Mohinda Mohan Nahi, my lord. An interesting thing is his my lord grandson wrote the Assam land and the line. And my lord, his land is also in Bosista, my lord. Many land, my lord. If the government make a sincere effort, they can settle this problem, my lord.
Now, we understand the problems of the state also. You also as a lawyer should understand the problem of the state.
Problem, my lord.
Where from would they bring land?
In Sinsali, there is land losses. Vast land.
Vast land in Sinsali, my lord.
Vast land for other purposes also, no? Only for settling. And you don't remain, you and your wife, you procreate, you have children, children will have grandchildren. How long? Welfare, all right.
They are,
The garb of welfare,
they are
you have to
dwelling
make some
huts.
efforts on your own. Can't always live on doles.
They are living catched house, my lord. I have already mentioned.
The moment they allot some land where all of you would go, it would become a slum-like existence. Then you will come running that please regularize electricity, regularize everything because we can't live like animals. And rightly you will say that. Now where is the end?
My lord, if you not give the my lord land, only 1% 5 less or 1% less, then we can manage all these things, my lord. Because our life to livelihood is here, my lord. Not that he said test food, not that. Make them sincere effort. I can give my lord land where is my lord. Taken land of the government is there.
How do you have so much of information about vacant land?
I know my lord Sunsali area. I born and brought up in this area, my lord. I know.
Do you have land in your village home in excess of the ceiling
Yes,
limit?
my lord.
And you will contest the ceiling laws to your last breath, and you're asking the state to give you.
Our land also got down chilling, my lord.
साढ़े पाँच बीघा लगे
Non-permitted की होगा.
No, no.
You hail from which place, Mr. Chaudhary?
From 1860, our computer is here. Before that, we are from Nalbari.
You are from?
Nalbari. Before 1860.
Arguments heard, judgment reserved. Give your appearance slips and please remind the Advocate General whenever he is here, we will ask a few questions and then we'll deliberate.
I'm so obliged.
Item 22,
first time.
No, 1 to 4.
Awaiting the service of notice and appearance of respondent number 1.1 to 1.5. The matter is again adjourned to January.
I am disturbed like. Well, but the office note says, my lord, they have moved from that place. And I do not have any further, my lord.
Then
application.
perhaps you'll have to find out, then fresh notice with the current and present address. Here. It appears that respondents number 1.1 to 1.5 have left their original place of residence. Stop. Let fresh notices be issued to them on steps being taken by the applicant within a period of 3 weeks, including furnishing of correct and present address, returnable on so and so date.
My lord. Look, can a line be included? If I cannot find out their addresses, then I may be allowed to take certificate service by way of, my lord, paper publication.
And that we will do. If you don't do it by, let this first come and then you will
If
do
this
it.
is included here only, my lord.
Otherwise
I
also
will save some time,
1, 2, 4, 3 days, we may not.
My
So
lord,
let it take time.
my lord. I am disturbed.
5th January. For admission, item 23.
Wait, please, Your Worship.
Yes.
Yes, my lord. Thank you. I'm agreed by the order dated, my lord, 2/2/2024, passed in WPC number 6013/2023, by which, my lord, direction was issued to provincialize the services of the petitioner from the date of her initial appointment, when the school was adventure stage, my lord. So my lord will find the impugned judgment at page 76.
We find that you are challenging it on 2 grounds.
Yes, my lord.
One,
First ground is
that her appointment in the year 1990 was
90.
not correct.
yes.
So this ground does not exist so far as you're concerned, because all others except one principal of the school who was appointed in 1976, all others were post 1980,
Yes, ma'am.
and you have regularized their service.
Subsequently, initially.
No, one by one.
Yes,
The second ground of yours is, your ground of challenge is that when she was appointed in 1990, there was no post sanction.
yes.
Have you said this with respect to others whose services have been regularized?
My lord, at the time of,
We are asking you pointed question, just answer that and be done with it. See, we have condoned a huge delay only for this reason. Now, where is your statement in the memo of appeal that others who were appointed post 80, they were appointed against sanctioned vacant post, and therefore they were given the benefit of provincialization from the retrospective date, and not this respondent?
no one is appointed against sanction vacant post, because in 1980.
Then
in 19
be happy with the judgment.
my lord, just one thing, my lord. Because in 1980, the school was in venture stage. Because in venture stage, the question of sanction post doesn't arise. Question.
But you have given it to everybody, no?
Yes.
Then what is the line of distinction?
The only line of distinction is that, my lord, at the time of provincialization, when it was given effect to, at that time, there is no post of Hindi teacher. The Hindi teacher post was allotted in the year 2014.
So others who were given, they were against those sanctioned posts.
Yes.
Where is that statement?
Statement is not there, my lord, to that effect, but fact is that
No.
when the school was provincialized,
No.
those posts were,
Now, what do you mean by sanctioned post?
at the time
The
of,
post of teacher, she was teaching.
she was teaching,
She was teaching since 1990,
yes,
and
ma'am.
she was teaching Hindi.
Yes,
Correct?
yes.
Now, your DEO writes that her services should be confirmed. Your department.
Yes.
I don't know which objection have you taken and why? And you have not taken that objection with respect to others. You would have understood that unless there were a post. Now, this post comes from another madrasa
Yes.
or
Another
some school,
Another school.
another school. So let it come, but she was teaching Hindi there.
And there is no dispute regarding
There is no
her continuation, my lord.
Later. Heard Mr. Khataniar, learned advocate for the appellant state, and Mr. M.K. Chaudhary for the sole respondent. The appellant state has challenged the judgment dated 2/2/2024, passed by a learned single judge of this court in WPC number 6013 of 2023, wherein the claim of the respondent of being regularized from the date of her initial appointment has been allowed, and the appellant has been and the agency of the appellant has been directed to enforce that her services are regularized, that the services of the respondent is regularized with effect from 1/11/1990, reserving her entitlement to the salaries as due to her from the said date, and that she would be covered by the provisions of Assam Service Pension Rules 1969, making her eligible for pension and other pensionary benefits. The respondent was appointed as a Hindi teacher at Kaimari M.E. Madarsa in Assam on 30th of October 1990 by the management committee of the school. Though the school had been provincialized in 1980, but this provincialization was kept in abeyance by the government for some reason. Because of this, all such teachers who had joined during the period when the status of the school was effectively like a venture school, because of the abeyance of the order provincializing the school, all teachers appointed during that period remained teachers of a venture school. The appointment of respondent number 1 was later approved by the District Elementary Education Officer, Dhubri, on 6th of October 2004. In the year 2008, when the ban on provincialization was lifted, when the provincialization was effected, the services of all others, including the staff and teachers who were appointed after the respondent were provincialized with the retrospective date from their joining. However, in the case of the respondent, her services were regularized prospectively from March 10, 2015, ostensibly on the ground that such regularization could have been made. Such regularization could have been made only after the creation of new post of Hindi teacher in December 2014. While the representation of respondent was under consideration, she retired on February 28, 2023, but challenged the decision of the appellant in regularizing her services only from March 2015 and putting her in the National Pension Scheme, which is the new scheme. The contention of the respondent before the London single judge was that her appointment had taken place when the school was at a venture stage, as by that time the school would not have been taken to be a provincialized school. Stop. Since all other teachers appointed after her had their services provincialized retrospectively, and even the DEO, Dhubri, had recommended for regularization of her services from the date of her appointment, she deserved to be treated equally along with other teachers whose services were retrospectively regularized. The only contention of the appellant before the learned single judge and before this court is that since the respondent was employed in 1990, when the school was in a venture stage, the appointment was not valid for the purposes of regularization. Her appointment, as is contended by the state, was against a non-existent post, which post of Hindi teacher was created only in 2000, only in 2014. Stop. The other ground raised but not pressed was that the respondent did not qualify for her services to be regularized for the reason that she had not served for at least 2 years in the venture period before provincialization, as required under the Assam Elementary Education Provincialization Rules 1977. And therefore, she was ineligible for retrospective benefits. None of these grounds found favor with the London single judge for 2 reasons, namely that others who were appointed during the period when the school still remained at the stage of a venture school were given the benefit of retrospective regularization of their services. And that after checking the records, the DEO had also recommended for giving the same treatment to the respondent. Even otherwise, the ground taken here in appeal by the state that the post of Hindi teacher was created only in 2014 is not understandable, as the school in question at the venture stage would not have had any sanctioned post in any subject against which other appointees were given the benefit of regularization, retrospective. We do not find any reason for differing with the view expressed by the learned single judge comma, holding the respondent to be entitled to be to be regularized from the date of her appointment. And if that is done, comma, that would automatically bring her in the category to whom Assam Service Pension Rules of 1969 would apply. Thus, finding no merit in this appeal, same is dismissed.
Obliged.
Highly obliged.
Respondent three, sole respondent. Which other respondents you have made? Mr. Kataniar? How many respondents? Mr. Chaudhary was not the sole respondent, the
Yeah.
pro forma respondent.
Pro forma respondent.
Only respondent number one.
Obliged.
Item 26,
Tipkai. Yes, Mr. Nath,
I have.
what has
filed-
happened
I
to the
have filed-
bridge on Tipkai River?
Lordship, I have filed an affidavit today. My instruction.
You have
is
filed it
An affidavit for the respondent number 3 today.
today?
Today, I have given served the copy to my learned friend.
Hmm.
But my instruction is that there are two difficulties because of shifting of the APDCL high tension wire at that line.
There are two difficulties.
Two difficulties, that is why the construction.
What are those difficulties?
So number one is the shifting and construction of new overhead high tension line by APDCL over that portion where the bridge is to be constructed. And the second is relating to the process of acquisition of land.
No, the bridge has to be built over the river.
Over the river, but the.
Are you seeking for any land for the causeway?
But,
I don't think. Where is your affidavit? Give us a
Yes,
copy,
yes,
of,
Lord.
copy of that affidavit.
Yes,
Give us.
Lordship.
It is not on record, but then
Lord,
we'll have it on record, but we'll
Yes,
see what is.
yes, yes.
Which paragraph?
Kindly come to 6, 6 and 7. These are the two difficulties they had. 6 and 7 kindly see.
15 and you over it 15, right? Some power. That will remain. It will be the responsibility of APDCL
Lordship, these are the.
to have it properly encased, because they can always raise the height. But then, you see, you're not touching the level of water. Your bridge would be above the water level.
What I am informed, Lord, in those areas.
Due to non-completion of the process of land acquisition for the construction at Pulkari under South Salmara. No. This is, so who is responsible for it? You are responsible.
In fact.
We are not asking the contractor then, we are asking you.
No, in fact, in paragraph 7, we have said that some amount of for land acquisition we have already has been deposited to the DC. Some amount is awaited, they are taking steps,
No, with regard to the statement made in paragraph 9 of the petition.
Kindly come to the next.
This affidavit appears to be an affidavit of the contractor.
No, this is by the chief engineer, no? Ultimately, this is the region.
The remaining amount of the cost and compensation of the said items is still to be received.
The amount has to be.
We are asking you, are you defending the state or you are for the engineers?
No, for the state. No.
And then where is the necessity of putting in paragraph 7?
The chief engineer, ultimately, we have to deposit the amount to the deputy commissioner's office for it.
No, so what have you done?
This amount.
Then we hold you solely responsible and not your engineers.
They have not received the amount. It is under process. I'm told.
That's what I say. They have not received the amount because you have not remitted to their account.
But the 65.
I think you followed what we are saying.
I follow. Yes.
Engineer and contractor are not to be faulted. It's your fault.
From the chief engineer, I got the
Then what do
instruction.
we say?
But Lordship may, but take on record the affidavit, what is the difficulty we have? We are facing, Lord. We have said.
You rectify your affidavit. Ask for a withdrawal of this affidavit, will permit you to do so.
No, as
This is
on,
an affidavit which will bring you in dock.
but as on today,
File a properly
Lordship,
conceived
from
affidavit.
from the,
Withdraw this affidavit and file a proper affidavit.
From
This
the-
affidavit puts you in the dock. I repeat.
Lordship.
Now, this affidavit, if we accept it on record, good that we did not have it on record.
May I please, your lordship?
Will-
Lordship, can I have a
From-
5 minute indulgence, my lordship?
From
Humble
the,
prayer, my lordship, before your lordship.
We have understood your sentiments. We have understood the response, the emergency in the matter. Everybody is using engine boat, which can capsize any moment, and the difficulties.
Lordship,
And
only
then
3 workers are working there, my 3 laborers are working there, my lordship. I
Three?
myself visited. Yes, my lordship, only 3 laborers working there. I have photographed my lordship. I have addressed, new photograph I have.
but I'll take the.
And my
instruction to the
lordship-
government, Lord, and
Give your
I'll.
lordship time.
will-
1 minute, my lordship, kindly. 1 minute.
we will get it constructed. No, your photographs is not going to cut ice. Now, we know how to get the matter, get constructed. Mr. Nath,
From the
withdraw
department-
this.
Yes, yes, Lord, from the
Mr. Nath,
department.
learned advocate for the respond number 3 seeks permission to withdraw the affidavit filed yesterday
Today.
and file a fresh affidavit indicating the stays of the construction of the RCC bridge over Tipkai River and reasons for the same not having been completed within the stipulated time in the year 2021. It noted that there was a disclosure in the House of the Legislature that only 62% of the work has been done. Awaiting the fresh affidavit on behalf of respondent number 3, the matter is adjourned to.
Lordship.
We are adjourning it to December, not January, December.
Lordship.
We are not satisfied with that.
Lordship.
Can it be any date in the month of November, my lordship? Humble prayer, my lordship, if possible. If it not inconvenience the lordship, my lordship, can I seek
Look
November?
here, we can't put into gallows, no, Mr. Nath. So we have to see what is to be done. That affidavit, Mr. Nath, you should have been careful.
Lordship.
You can't wait that kind of an affidavit to be filed. This was not an affidavit on behalf of the department.
No, this is.
This was not an affidavit on behalf of the
Lord-
contractor. You can't say this, no.
This is.
I'm giving you a passage, safe
Lord-
passage to take
Lord-
away. Because if we have to rely on that, then you are to be condemned.
My lord, Lordship. From the department, I'll file it, Lordship.
Yes.
12 December.
Of late.
For the department, you say, and then we'll ask the state. You are representing the state.
Lordship.
Department is all right. The engineer is not here.
Lordship.
Fund has not been received. Has it been remitted?
No,
Has it been remitted in the account?
these are the reasons, my lord.
Therefore,
I'll place.
therefore, the affidavit means that now no more money, and therefore, whatever has been made, nothing can be done.
No.
We will read this from the affidavit.
No, kindly, my lord. I'll place it, my lord. Lordship.
Developments, my lordship.
Item 27.
Yes.
So I think the respondent number 6,
Yes.
I filed my affidavit on 4th of 4/11/2027.
Is it here, Mr. Zakir? Is the affidavit filed on 4th of December here?
4th of November.
4th of November, and December has not come forth, no.
No, as far
Have you given him a copy?
Yes, my lord.
Not yet.
Again, the learned advocate who's appeared on behalf of respondent number 6 submits that an affidavit in response to this appeal has been filed only on 4th of November, which has not yet been placed on record. Let the affidavit be placed on record and this case be listed on your date in December, November last.
28 November. Item 29.
May it please your lordship. So, I've just received instructions electronically that the sanction has been received and the It will be carried out.
What has
the
been
day
received?
which- The sanction from the government. The Deputy Commissioner Naga's office has just sent me, my lord. I have sent it by email just now. I've received it.
Should the affidavit has been filed?
MS, yes.
Lordship, an affidavit was filed, Your Lordship, where it was stated that the Deputy Commissioner has forwarded the required sum of money, Your Lordship, on 15th of September 2025, Your Lordship.
No, no.
So that was placed, before
MS
Your Lordship.
Sharma,
Now it's
she's
in
Bordoloi.
provided.
And go.
MS Sharma. Learned Counsel for respond number
3 to 5.
3 to 5. Submits that she has received instructions digitally and shall file the affidavit required and shall file the required affidavit shortly. Let this case come up for consideration again on give a date in early December.
2nd December. Supplementary list, item 32 for admission.
No, no, this is, you're giving me the hearing file. Just a minute, give us a minute.
Lordship.
Just. This is 569. What was the number of your writ petition?
My petition number was, my lord,
69.
5965 of
This one does
25.
not find any merit in the petition.
59. 59.
5969.
5965.
5969.
There is no consideration of his case.
No,
It was considered.
No. With respect to him, the disclosure only is at internal page 38 of the judgment.
Page 23, kindly come over, internal page 23, 421.
Internal page 23.
Yes, Lord. Insofar as other petition being number 5969.
5969 is concerned.
This is respondent submission. And para 27, internal page 18.
No, no, just a minute, submitted. You didn't have it.
petitioners,
This is the version of the respondent,
मतलब
so far
petitioner's
as that
version,
paragraph is concerned.
petitioner's version is page 21, para 33.
Let's see, let's see, the, no,
Page 34 may also be low, my lord, para
so
34.
that's in the table.
Para 34 may also be low.
No, the grounds in paragraph 38 and 39 cannot be reconciled with the judgment. Yes.
But the reasoning, page 50, para 56, page 35. Why the petitioner's case was rejected?
Now, whatever paragraph they have, this.
Can you just wait for your
Madam,
turn? We are asking him. For your turn. We will not dispose of the petition without hearing you.
Madam.
Mr. Nath, you have to show that requirement 4.7 of ITB.
Yes, that my lordship will find at page 97, no?
At page
97. Four point seven, last sentence, bidder who meet the minimum qualification criteria will be qualified only if
bidders who meet the minimum qualification criteria would be qualified only if their
available bid capacity is more than the total bid value. The available bid capacity. will be-
available bid capacity is more than the total. What does this mean?
The available bid capacity is to be assessed, this is the formula, my lord. The maximum value of the civil
Value
engineering
of the
works.
existing commitment and ongoing work administrative. Oh, when you asked for an explanation?
Yes,
My lord, they have page 64 law.
No, you asked for an explanation.
lord,
I'm talking to Mr. Nath.
Yes.
You asked for an explanation for him for not having disclosed the work pertaining to construction of girls' hostel.
lord, two works,
And he gave the reason that the work has not started, therefore he has not mentioned.
lord,
Now that's not sufficient because the assessment is made on the existing commitment. Commitment is if he gets the
wow,
work order.
lord,
That's all right. But
No.
then we are not on that.
No.
That's very easy for you to allege. But then this was the response of the appellant, that is the writ petitioner, was where was it considered?
the rejection order, my lord, that is impugned in the writ petition.
Rejection order is impugned in the writ petition.
Yes, my lord. Kindly come to para, matlab page 44,
No, just a minute.
lord.
Now you cancelled, you cancellation of his tender on 6/10/2025,
6/10/25.
and then you re-tender it on 7/10/2025.
7/10.
That means you decided not to give it to the lowest bidder.
But considering the,
Can you do it in a gap of a day? That means this is mechanical. Let's see the order dated 6/10. Where is the order dated 6/10? Where is it on record? The contention of the appellant is that it was never decided.
page 72.
Cancel. This is cancellation. Where have you responded to his response?
No, it was-
You chose to just cancel it and not give any reason.
no, like, he filed the.
He filed the
reply.
explanation.
He filed the reply.
Yes, he filed the reply. And where is that response that your reply is rejected?
No, in fact, I did not find the affidavit in opposition was filed in this case. Only one of the, considering the violation of clause 4.7, it was decided.
Taylor. You'll have to file your response to this appeal. You did not file anything. Where is that order? We need that order disposing of his reply.
The decision taken by the authority.
Decision taken by the.
Sure.
This is not your private affair, no? Mr. Counsel, you are very eager to argue.
Mhm.
Where is that judgment which says that the sanctity of contract has to be maintained?
My lord, I am just saying, my lord, what a minute.
Have you brought Subodh Singh Thakur versus?
Yes, yes,
Twelve?
yes.
Where is
I
it?
bought one.
Huh?
Subodh Singh. Subodh Singh Rathore.
Subodh Singh Rathore.
Yes, yes. I have. For the recent judgment of the office.
We only talk about recent judgments. No?
My lord, I, to my humble understanding.
Take it. What is this thing? We have heard Mr. B.J. Ghosh, learned advocate for the appellant, and Mr. Nath for the respondent. By the impugned judgment, 4 writ petitions, including that preferred by the appellant, was disposed of in a composite manner. But, it is alleged that the grounds urged on behalf of the appellant, writ petitioner in WPC number 5969 of 2025, was not considered. The case of the appellant is that pursuant to the notice inviting bids online for balance work for construction of model secondary school in tea garden areas of Assam in the district of Kachar, the appellant had applied and had passed the stage of technical evaluation and financial bid evaluation. He had been declared L1 However, shortly thereafter, the executive engineer, bracket H&E, by letter dated 15/9/2025, sought an explanation from the appellant regarding him having suppressed the factum of an ongoing work which was necessarily to be disclosed in accordance with clause 4.7 of the bid document. of the bid document. Which page did you say that bid document requires?
64 mile.
Bid document requirement is 97.
90. The letter is basic.
It starts at 97.
Four point seven of the clause 4.7 of the bid document provides that bidders who would meet the minimum qualification criteria will be qualified only if their available bid capacity is more than the total bid value. First off, the available bid capacity would be calculated in accordance with the procedure stated First off, there is a note appended to clause 4.7 of the bid document which says that any misleading or false representation in the forms, statements, and attachments submitted in proof of the qualification requirements would lead to disqualification of a bidder. It appears that since the appellant had not disclosed about his having been allotted a work pertaining to the construction of a girls' hostel at Janta College, Kabuganj, such an explanation was sought from him. The appellant had responded by saying that that was not for the purposes of misleading the technical evaluation committee or the technical or financial evaluation committee. But it was deliberately not stated as the work pertaining to that project was not likely to be completed within 24 months, as there was no physical progress of the said work on the ground, which was primarily for the reason of non-finalization of the architectural drawings and identification of these and the handing over of the site to him. Without caring to consider the explanation, the contract of the appellant was cancelled and the work was and a retender for the work was issued was cancelled on 6/10/2025 and retender for the same work was issued on 7/10/2025. The appellant alleges that he was communicated about the cancellation of his contract only on 7/10/2025. There is nothing on record, Mr. Ghosh has argued, which would indicate that the explanation offered by the appellant was ever considered by the respondents. He has further submitted that the requirement under clause 4.7 of the bid document was for a purpose of ascertaining the bid capacity. Non-mentioning of a project which had yet not kick-started, would not have been would not have been necessarily to be informed for the reason that it would provide no INDIC for assessment of the available bid capacity. First off, there is no dispute with respect to that existing work allotted to the appellant having been started in any manner whatsoever. He has further submitted that the sanctity of the tender must be maintained. First of all, public tenders are the cornerstone of any governmental procurement or work related process, which ensures first off, the state must ensure transparency, competition and fairness in the allocation of public resources. This theory emanates from the doctrine of public trust. The state has an obligation not to indulge in any favoritism or discrimination. The award of government contracts through public tender, therefore, has to be treated in a very serious way. Without considering the explanation offered by the appellant, and without his being served with the information that the reply made by him was not satisfactory, the tender was cancelled, and the tender was cancelled on 6/10/2025, and the work was hastily re-tendered on 7/10/2020. This, Mr. Ghosh argues, is obviously to do away with the lowest bidder, perhaps to accommodate someone else. Mr. Nath shall respond to the aforenoted arguments by filing an affidavit, as we do not find any record, as we do not find any order rejecting the explanation offered by the appellant. What is on record is only the cancellation of the contract with the appellant and re-tender of the same work. The affidavit shall be filed. We are not stopping the re-tender, but we'll put you to this. I mean, there's a government tender. You can't do like this. You cancel it. You don't inform him, and then you re-tender on the next day. In this kind of haste is not shown in other works.
Well, in the records, I don't find, but the submission on behalf of.
File your affidavit.
Is there.
Well,
The
affidavit
was
will-
rejected. It is
My lord, it may be subject to my lord.
No.
No.
logic.
That we are, let him participate.
Yes, he can,
My, lord,
let him.
we do prejudice my right in that. May,
In the meantime, if there is still time available, the appellant may participate in the
the
re-tender.
10th is the last day.
Huh?
10th is the.
10,
last-
11 is
May
the last.
participate in the re-tender.
Yes,
May be permitted to participate,
Not subject to, without
but
prejudice.
it shall be subject to the outcome of the, no. Participate in the tender. We'll see.
logic.
My
Yes.
lord, this, my lord, with all respect, my lord, this, our participation without prejudice to right involved in this writ appeal, my lord. No, yes, my lord, this,
Which will not be to the, which shall not be to the prejudice
yes,
of the appellant so far as this writ petition is concerned.
Obliged.
So that this appeal is concerned.
Obliged.
Lord, we'll file the affidavit within 10 days, Lord, and Lordship will give us a date.
That's
January,
December.
first week. First week,
First,
Lordship. Hi, Lord.
no, first week we are not here. Second week.
Lordship.
11 December.
11. Obliged. Then Lord, we'll file by 26, Lord. Highly obliged.
Daily list for hearing item 30.
Yes,
This was that.
Mr.
matter-
Kanodia,
Yes, Lordships. This was that matter regarding 16(2)AA.
that's right.
We have on 23rd submitted our written notes of argument, Lordship.
It is
and-
before us.
And a separate compilation of all the circulars and the judgments,
Yes,
which we relied on the last occasion when we argued the matter before. you.
yes, we have that.
Take up the matter
After?
sometime.
Why? Mr. Kale is not here.
Lordship should be here, except that. Also, they have submitted our written submission.
Lordship, it was only posted for written submissions because Lordship had heard at length.
Yeah, we had.
The moot point, Lordships, which
The
all
moot
from
point is all right, Mr. Kanodia, but you tell us.
Lordships,
Now, without 2AA, without 16(2)AA,
Lordships.
there were fraudulent ITC claims.
No, Lordship. To my,
Yes, there were.
I will, once our Lordship says, then I will complete.
Then the purpose is different. The purpose is to promote supplier compliance,
Lordships.
and you can do it by not engaging, by not engaging with such kind of a supplier,
Lordships.
forcing upon him to give proper disclosures.
Lordship.
And it's a two-way attempt to have everything, every document reconciled.
Lordship.
But then they are not denying you the ITC. They have to make that exercise.
Lordship.
And these circulars, which have been issued by the
CBS, Lordship.
CBS,
The board, the Central Board of India.
Central Board, they have taken into account this
Lordship,
difficulty.
so
They have
that-
taken into account.
Lordship, just to respond to this, what has fallen from your lords. I am with my lords that the condition may not be redundant, but lordships, the practical problem that where the supplier actually has given me supply has happened. And department only on the basis that it is not reflecting in 2B.
No, that argument you have made.
Lordship, that is
We
why
are-
this
you are
circular.
No, you are asking us to read down or
Read down, Lordship, I am not on the validity. I am only on the read down to the extent that in case of bona fide purchases, the benefit, if it is not auto-populating.
So before denying that privilege to you,
Lordship.
before denying it, the concerned officers shall make an exercise.
Lordship.
And if you produce the vouchers and everything,
Lordships.
and there is definitely.
Lordship, Lordship, that is my own.
Then don't ask for reading down or anything.
Lordships, reading down.
Reading down, yes, this is reading down.
This is reading down, Lordship.
All right.
This is my only
That
plea.
is no
Only,
issue,
I'm
because
not on the
practicing
constitution.
statutes, we can't.
Lordship, had I been on constitutional right, I would have argued with more judgments before your lords. But what has fallen from your lords on the last occasion, I restrict myself to that.
All right, Mr. Kel, you have concluded your
Lordship.
argument. We'll hear only Mr. Kel will pass judgment. When? Today, we have other work.
Lordship, then
There is
this
single bench
Wednesday,
or other?
this Wednesday, I am here again, Lordship, for some other matter.
Wednesday.
If your Lordships can.
Okay, let this matter be listed on Wednesday for final hearing and disposal.
Yes.
On Wednesday, नहीं date बता दो. I'm there on Wednesday.
On Wednesday.
12, Lordship.
12.
Much, grateful to you.
Ask him to be here. His argument is over. He just wants that. I thought he's challenging the very insertion of 216(2)A.
What has
That
fallen from your lords on the last occasion, I have restricted my service.
That would be otherwise very difficult. Now we had forgotten that you had restricted your.
Lordship, I have written that is fine.
All right.
Grateful to you. Much.
Item 31.
Yes, Mr. Indranil.
Madam. Although the pleadings might appear to be a little voluminous, but in my humble understanding, the issue is on a very simple point. Madam. Yes, sir.
Mr. Chaudhary, not today. There is a problem, single bench, very large matter. So Can it be concluded in 10-15 minutes?
It will take a little bit of time. And in that case, my lord, may I pray, there's some urgency on our part because they are, the order impugned, they had initially issued it on a trial basis for 3 months.
We will
On,
keep it next week only.
Uh,
We'll keep it in the month of November only.
If it is in the next week, Lordship, can it be on Friday? Because in between I'll be out of station.
All right, we'll.
in that case, my lord, can it be on 25th?
That is fine with me.
25th is all right. Let this matter come up for consideration on 25th of November.
So